So the request came from the developer who was on record at the time. Whether there was somebody else who was in first position on the bond is a question, but the request for release of bond is supposed to come from the party having standing, and it came from Janet Clausen.
I understand too, and I think that one of the things that was done by your solicitor is there's a learning curve with everything that's taking place. And I know I've worked with Mrs. Adams at a number of other municipalities where we have been, and now I don't think that could happen, because now what happens is it's put and memorialized in the final approval resolution that if in fact the developer who goes through the approved lots then has to also sign and join in with what they call a developer's agreement. Maybe you didn't have a developer's agreement there, but again, we're just asked that we not be tarred with a brush that maybe doesn't exactly fit on all fours with those parties that are also principals of this organization. That we, it's not that we're trying to duck or hide or avoid or distance ourselves, but had there been a developer's agreement back then, and I wasn't the attorney representing them, maybe that situation, then you'd have somebody that you could call in the park as far as that's concerned. All we're trying to say is that there was something that was contemplated, and I do believe that Mr. Spatell has testified, you can ask your own professionals on that, is this development and this configuration and the figures that substantiate what we have here are going to impact favorably on what you have identified or as a problematic case. And that's something that we're prepared to do. And again, we were coming in, now certainly as part of our EIS and everything, we could go back to the drawing board and modify our plans and just eliminate that road. I mean, it's just that it's something that we thought here was an opportunity to demonstrate that, we've listened to you, we've heard some of your needs and wants as far as maybe redirecting some of that traffic, but
just speaking to the issue at hand, which was the environmental impact statement. I had met with the applicant last year, and we had discussed much of the stormwater basin. Certainly, he's designed it addressing the RSI standards, but I think that there's some generic issues in that area that require additional documentation. It's a problematic area where there's downstream flooding. To the extent that the issues have been brought up tonight on that flooding from the board itself and from our own letter that suggests that we get some sort of environmental impact statement on the issues regarding groundwater and stormwater, we would recommend that the board consider delaying their completeness until that information is submitted. I think the other issue was relative to the trees. Orifice wasn't aware of issues related to the trees as they pertain to this development. I think through the process recently, we've discovered that addressing those specimen trees and how they'll be maintained is another element of the environmental impact statements that could be benefited from getting that information. Certainly, we don't want to suggest that we build houses and have the trees be within approximate distance that the roots will be cut during the foundation installation. So it's our recommendation, based on the testimony tonight and the record that we put back in June, that the board consider delaying this until some abbreviated, at least, environmental impact statement is submitted.
And we will comply. The only reason we were having a little bit of a colloquy here, because when we're all over and done with tonight, we're going to have to suggest to you what date we can have that done with, because you may say, we talked about, next month, the 19th. Well, when you come back, as your solicitor said, we have to have it in 10 days before, so that your professionals have an opportunity. That isn't going to happen. So that's the only reason we were having it. We will do we'll modify and update the EIS and make specific address or redress of the issues of the groundwater, so that you can have a little bit more information, and we'll identify the trees once we have a chance to take a look at that.
Hey, Frank.
Yes, sir.
Will you guys take back the ownership of that other
No.
basin?
You talking about me personally?
No, I'm saying, yeah,
We can't do it.
I'm just throwing it out there, that's all.
Right now, that basin is still in the ownership of they have not been released from the bond, so the township doesn't own it yet.
There you go.
We don't know.
Okay,
Not yet.
all right. I was just
I understand, but
trying to help.
the point that I was making is that, and maybe what it needs is it needs maybe a chance or an opportunity to come to Township Committee, because it looks like we're gonna have a little bit of time, and see if this is just a minor opportunity for you to alleviate some of the problem as far as the traffic is concerned. It may be something that the township would consider, because it wasn't that you accepted the other one in a vacuum. That I do believe that this was contemplated. Otherwise, the size of the pipes and the piping issues, we may be able to better enhance the drainage situation that exists out there. So we know that we have that burden. We know coming in here tonight that our biggest problem or hurdle was getting over the homeowners association, because it's not a type of development that lends itself well to a homeowners association. Well, we will address that. Again, I'm sorry.
I think in your issue of looking at the drainage and all that is, not only is it the drainage stuff, but what happens to that water, obviously it's going to be a retention.
Retention.
It's hot.
Wet pond.
Right, wet pond, so we need to look at what happens to the areas around us when that water leaches back in, re-infiltrates or whatever, recharges, because that seems to be a problem we're having, especially in this area. So those numbers need to really be looked at.
Also, technically, would require a design waiver request. Under ordinance section 185-14, of course, it requires your subdivision to be designed in accordance with the state RSIS standards, and not maintaining your water on site would be an exception to that. It's not a variance, but it would be a design waiver, and it'll be dealt with that way at the time of the